Ladies and gentlemen, first of all, I would like to thank you for the opportunity to be here, to present our thoughts and ideas. It is a great honor for me. I would like to thank, of course, Central European Academy and Ferenc Mádl Institute for Comparative Law. It is also an honor to be the closing member of our panel because my pre-speakers were wonderful, so I hope I will not be so terrible in compare with them because I was like, wow. Let's move on to our presentation. Why I'm saying our presentation? The thing is that there should be a Dr. Jan Provaznik with me as well, but unfortunately due to his duties, he was unable to arrive, so I'm presenting our co-article. My name is David Čep, and our topic is Unchained, yet prosecuted, and also focus on the topic of criminal responsibility of victims of human trafficking, which is quite a small topic hidden inside of the huge problem, huge idea of human trafficking. At the beginning, of course, you all understand, you know the concept of Article 4, so just to make it sure, the Article 4, first of all, states the prohibition of slavery or servitude. Second of all, it also prohibits the performance of compulsory labor, forced or compulsory labor. But as you can see, there is nothing about human trafficking. That's very important to bear in your minds. Article 4, together with Articles 2 and Article 3, according to the judiciary of ECHR, enshrines one of the most fundamental values of the democratic society. And the case Silidian versus France and Stammer versus Austria were two human trafficking cases. So that's important to know that the problem of human trafficking is deeply concerned by the European Court of Human Rights. As I've said before, the Article 4 does not stipulate expressively the term of human trafficking. Yet, as the ECHR stated before, and as we know from the beginning, of course, the provisions of the ECHR are not the sole framework because for the reference of interpretation of the rights and liberties enshrined in it, but ECHR also the court uses to interpretation another instruments, usually an international treaties. For example, in case of human trafficking, the Convention on Acting Against Trafficking in Human Beings, hereinafter Convention, and the Palermo Protocol, but also in concerning EU countries, the EU law, for example, directive that I will speak later about, and also the UN Convention Against Transnational Organized Crime as well. According to the court, a conduct or a situation may give rise to an issue of human trafficking if all the requirements stated by the Convention and Palermo Protocol are met. What requirements has to be met to be sure that we have a case concerning human trafficking? Article 3, letter A of Palermo Protocol, and Article 4 of Convention states that human trafficking is defined by three definition points, 3 marks. The first is action. I will not read the definition for you, of course. You can read it from my presentation. But there has to be an action, for example, recruitment or transportation. Then, what is important when we are concerning human trafficking is the means. The means are essential because the means are threat, use of force, deceived, or, for example, abuse of power or position of power. Last but not least, is a purpose. The purpose, if we are concerning human trafficking, is exploitation. And exploitation for at least a minimum. For prostitution or for slavery, practices similar to slavery, or, for example, for removal of organs. If all 3 requirements are met, then we have a human trafficking case. According to the court, the limiting compliance with Article 4 only to direct action of the state is not enough. It would be inconsistent with the duties of the state, with the international instrument that states are obliged with, an instrument that court uses to interpret the Article 4. So it means that the states have to follow their obligation stated also by the international law. These are called positive obligations of the state, and these obligations are used to interpret the Article 4 when concerning human trafficking. These obligations are both of substantive and procedural character. I will focus on the substantive character, but the procedural is as well important. For example, duty to investigate human trafficking cases, but also, and this is very important for the victims of human trafficking, the duty of the state and the right of the victims to effective investigation. It's just also stated by the court judiciary. If we consider substantive obligations, according to the court, Convention and Palermo Protocol provides for need of comprehensive approach to combating human trafficking. What does it mean to be a comprehensive? Well, comprehensive, it means that we have to use various instruments to make sure that we will prevent human trafficking, provide the support for its victims, and so on. And of course, to make sure to punish the human traffickers as well. One of those substantive obligations is obligation to put in place appropriate legislation and administrative framework, also mentioned in VCL and AN versus the United Kingdom, which was the human trafficking case, one of the latest ones of these of the court. The court also stated that Article 4 calls for need for so-called operational measures. So not just to put in place the legislation, to make sure to protect the victims, prevent the trafficking, and to punish the traffickers, but also to make sure that state will cooperate, will search for the cases of human trafficking, and will provide some important help to the victims of human trafficking to make sure that they will report the cases and they will not be afraid. Afraid of what? Well, one of the operational measures, according to the court, is so-called non-punishment provision. Non-punishment provision means the duty of the state to provide the possibility of non-prosecution or non-punishment of the victims of human trafficking for crimes that are connected with human trafficking, with themselves being a subject to human trafficking. According to the court, there is no general prohibition for prosecution of the victims, yet there is the obligation of the state to provide the possibility to not prosecute or not punish the victim if the certain requirements will be met, also mentioned in the VCL and AN versus the United Kingdom. Well, what are those operational measures? What are those duties connected with non-punishment provisions? Sorry. First of all, we can see some procedural aspect and again some substantive aspect. The procedural aspect was stated in VCL and AN versus the United Kingdom. The criminal prosecution in case where the status of the person as possible victim of the human trafficking is not clear, was not considered at all, despite the indicators of such situation, will necessarily bring the decision of breach of Article 4. In VCL and AN versus the United Kingdom, the situation was simply that in two separate cases, the British police officers entered into premises, family houses, that were turned into marijuana factories. They were they were growing the cannabis plants and then transferring it into a marijuana. And in these two totally separate cases, they found minors inside both of them, taking care of the marijuana, of course. Both of them were prosecuted. The case facts were quite interesting and quite broad, so I will just point out the name of the case. They both were prosecuted. In both cases, there was a suspicion that they might be subject to human trafficking, but it was not clarified by the state a lot. Or, by my humble opinion, the state took it into consideration, but decided that no, they were acting in their own will. They were not subjected to the human trafficking, according to the United Kingdom. The court had a different opinion. He said that according to the case file, the British authorities did not make sure enough, did not work with the possible indicators that those people were, in fact, subject to the human trafficking, and thus, because this procedural flaw, he decided that there was a breach of Article 4. In another case, GS versus the United Kingdom, criminal prosecution in case where the level of compulsion was considered as such that did not reach the exculpatory level. So what happened in this case? There was not a minor, but an adult who was subject to human trafficking, but the court decided that the fact that he was the subject of human trafficking did not affect him so much in committing the drug crime, meaning that there was not such a strong connection between the fact him being the subject to human trafficking and him committing the drug crime. And in that case, court decided that there was not breach of Article 4, was decided that the substantive element of connection between status of victim and the crime is key element as well. Well, I've promised that I will talk about criminal liability of the human trafficking victims. There are various criminal offenses that might be committed by the victims. For example, drug crime, as in both cases that I have noticed before. Usually, the foreigners are lurched into the country by fraud, deceit, or, for example, or by force, and then they are taken off the documents, as we have heard before, and forced to sell the drugs, typically in capital cities. You can see it in Budapest, in Prague, in Warsaw, doesn't matter. The situation is quite the same. Then there's a pimping. I'm not sure about the word. I was trying to find something more specific terminology, but you all understand what I mean. When someone is managing someone else's prostitution and taking the benefit from it. This situation can also be connected with the victims of human trafficking in case when the victim moves on in the hierarchy. Well, when the victim is good enough to put higher in the hierarchy and then manage the other victims of human trafficking. This can also unfortunately happen. We had the case in Czech Republic in 2020, 2021, and it was a 13 years old girl that was pimping a 12-year-old. Terrible situation, unfortunately happened. Then crimes against property, same situation. In case of children's runaways or children from some state institution where they are put because of the problematic home ground and so on. These are usually used as a pickpocket or for thefts or other types of crimes against property. Crimes against life and health, that's the most problematic. Trafficking with organs, bodily harm, or murders. This can also happen to the victims of human trafficking, typically when the organized crime is hiring or using victims of human trafficking under 15 years old. In Italy, I suppose there was such a case that one of those children murdered someone in the street, got payment for it, and so on. And it was, again, the situation when it was a victim of human trafficking committing a crime connected with human trafficking. Crimes against freedom, extortion, even human trafficking, again, the same situation with pimping. You move on in the hierarchy, and now you are trafficking the others, even though you were at the beginning, of course, the victim of human trafficking, and you are still the victim of human trafficking because you cannot decide of your own and free will. And of course, last but not least, crimes against public order, such as illegal crossing of state border or illegal stay. In compare with the others, of course, petty crimes. Well, I've mentioned non-prosecution and non-punishment provision. Here you can see Article 26 of the Convention and Article 8 of Directive of European Union. They both demand from the state to put such a non-punishment or non-prosecution provision into the legal order. It is a duty, but in order to make it possible to terminate criminal procedure or make it possible to not impose a punishment for the victims of human trafficking in case, to the extent that they have been compelled to do so. Compelled to do so in connection with the fact that they are themselves victims of human trafficking. Let's put it all together. So we have a victim of human trafficking that is compelled to commit a crime. For example, threatened or forced to sell drugs. Should we stop a criminal prosecution? Well, yeah, we can do that, or not to impose a punishment, of course. To grow marijuana, to transport precursors, sure. To commit a robbery, yeah. To search for new possible prostitutes. If it's minor, okay. The ECHR is quite friendly to minor victims of human trafficking, also being criminal offenders. If it's extortion, If it's aid with human trafficking, if it's committing a murder, that's a problem. That's a problem. Or another situation that victim of human trafficking takes initiative or oversteps. Well, in that case, we are not meeting the necessary conditions of provision of Article 26 or Article 8. Thus, no problem with prosecuting such a victim or imposing a penalty to it. The non-punishment provision has its limits when considering the criminal offenses. That's what is derived from the previous slides. If it's Article 2, right to life, definitely, even though the victim of human trafficking is forced to commit such a crime, the provision of Article 20, the non-prosecution or non-punishment provision will not apply in this situation because we have absolute right. Article 3, prohibition of torture, same situation. It is an absolute right. Even though someone was forced to torture someone, it would be quite hard to understand the situation when to figure out the situation when we would decide to terminate the criminal prosecution or decide to not to punish. Wow, and I was afraid that I will have nothing to talk about. Great. I underestimated the topic. Article 4, prohibition of slavery. The same situation as the situation I've mentioned before. The victim of human trafficking is trafficking someone else. Also, determination. I wouldn't think that ECHR, in the case that such a victim was prosecuted, would decide that there was a breach of Article 4. On contrary, not that just the non-punishment provision has its limits, but also the contracting states of European Convention and member states of European Union has their limits when they are implementing their positive and clearly stated obligations. Of course, I mean non-prosecution and non-punishment provision. According to Greta and according to European Parliament, the situation in all of our countries, I focused on V4, Czech Republic, Poland, Hungary, and Slovakia. Also took into consideration Austria, and thanks to Dr. Marszewski, I know that the situation is the same in Croatia. The situation is unsatisfactory. The Czech Republic did not adopt the specific legal provisions concerning non-prosecution and non-punishment, nor develop the guidance for law enforcement officials and prosecutors to take this situation into consideration. The Hungary, this information is not specific because I figured out today that in 2021 there was some novelization, and in case of minors, there is a specific provisions for them for termination of criminal procedure, I suppose. So at least something, but still to issue the guidance to the police and public prosecution. The Poland still missing the specific legal provision. The Austria, well, they have issued a decree and circular information for law enforcement authority, but still they don't have a specific legal provision, so Greta is saying no to the Austria as well. The Czech Republic, they have special provision in Code of Criminal Procedure, they have special provision in Criminal Code, and yet they have to strengthen their effort and extending the scope of those provisions as well. So the situation, even in Slovakia, that followed strictly the duty is not satisfactory according to the Greta. Last but not least, to the whole European countries, according to the European Parliament, the situation is not satisfactory as well. They have to adopt the clear provisions of non-prosecution and non-punishment. My final conclusions. There's a problem with implementation of obligations to ensure that victims of human trafficking may be protected from criminal prosecution or punishment, typically by a Central European state, by us. Then, during the last 10 years, fortunately, or depends, there hasn't been a decision of court concerning Central European countries and the breach of Article 4, which is a positive information. If we interpret it just like information, no decision, that's fine. But on the other hand, if we take a look into information on how much cases are handled in our countries, in Hungary, I suppose there were 170 human trafficking victims in previous year. In Poland, it was 94. In Slovakia, there were 30 victims, and in Czech Republic, we don't have statistics for number of victims, unfortunately. We have statistics for number of cases, but it's something completely different. 1 case, 10 victims, or 2 cases, 2 victims, different situation. And finally, the approach of court presented, for example, in VCL and AN versus the United Kingdom, the lack of procedural aspects leading to the breach of Article 4 provides an apprehension that the cases against state that did not yet implemented the non-punishment provision, the breach of the Article 4 could be concluded because of not fulfilling their positive obligation. Ladies and gentlemen, thank you very much for your attention. I hope I made myself clear. In case of any questions, do not hesitate to ask me, and have a wonderful day. Enjoy the rest of the conference. Thank you.